No. Okay. So we have 2 days left on requesting committee-sponsored bill drafts. Are there any committees-sponsored bill draft requests? Any at all? Okay, Monday is the last day for that, I believe. So get them in. Today, that is wonderful. Thank you for shutting the door. Didn't even realize that till you shut it. Okay. So today we're going to have a hearing on House Bill 2075. And to get us started, I'll recognize Jesse Pringle, our reviser.
Thank you, Madam Chair. Good afternoon, committee. Today, I'm going to provide a briefing on House Bill 2075. So House Bill 2075 amends only one statute, and that is KSA 38-2264. This is a statute that governs the processes for permanency hearings for children who are adjudicated to be in need of care. So specifically, KSA 38-2264 requires that a permanency hearing occur within 12 months from the date that the child was authorized by the court to be removed from the home. It also further requires that subsequent permanency hearings occur then every 12 months after that while the child is in custody of the secretary. The bill before you amends both of those requirements of 12 months to 9 months. So if this bill were to be enacted, that first permanency hearing would occur within 9 months of the date that the child was authorized to be removed from the home, and then any subsequent permanency hearings occur every 9 months. And if enacted, the bill would take effect upon publication in the statute book.
Okay, committee, are there any questions for the reviser? Okay, good job. Great job. First, we're going to recognize the proponents. There are 4 written only proponents that's on the S drive, and then we're going to start with Tanya Keys, Deputy Secretary, Department of Children and Families. Welcome to committee.
Hi, everybody. Thank you, Chair Howerton and members. I'm excited to be here today to support House Bill 2075. As you heard from the reviser, it changes Kansas law so that a permanency hearing for a child who's in the custody of the secretary in foster care out of home placement, instead of that permanency hearing happening at 12 months, the courts would hear it at 9 months and every subsequent 9 months thereafter. That's what this law changes. The purpose of the bill is to reduce the time that a child is separated from their family and kin while they're in the custody of the secretary in foster care. Specifically, our goals with this are to achieve timely legal permanency for children in foster care and to really improve Kansas towards national performance on timeliness in foster care. This bill reduces the number of months for courts to hear the child in need of care matter. So this is about a court proceeding and the number of months between their hearings. And again, as you heard specifically, it changes those number of months from 12 to 9. So that's the change. Just a little bit of background. Foster care is intended as a temporary service and support to families. When a child comes into care, we need to be providing supports and services to the family, their kin, the young person, so that they can achieve their permanency goal timely. When that happens, in terms of timely permanency, Kansas historically has not met national performance on this measure. This year, just looking at current data, the standard for children who leave care and they've been in care 12 months, there's 3 national performance pieces. The first one looks at time in care of 12 months. The national performance is 35.2 in terms of that's the timeliness. Kansas falls just short of that at 32.8. For children,
Representative Barth.
Madam Chair, just for clarification, is that days or months? I'm sorry, I just want to verify the 38 versus 35.
Good
days.
question.
Thanks.
Thank you, Chair and Representative. To clarify, the National Performance Standards looks at the number of months that is a child in care, that a child's in care for that. So if they're leaving care, we would want the national performance is at 35.2% are leaving within the 12 months, and we're just short of that at 32%. And that's specific to a cohort of children in that first year of care. There's two other measures that Kansas is also not meeting with regard to when we compare to national performance. So with that, for children who've been in care, for example, 12 to 23 months, so they've been in care a little bit longer, their performance, we would hope, would be 43.8% would be achieving permanency. Kansas performance falls short of that at 33%. So we're not there yet on those who've been in care 12 to 24 months, a little bit longer. And the same is true for those who've been in care 24 months or longer, and that's that third measure. And let me give you the specifics on that. So for children who've been in care 24 months or longer, Kansas performance is at 30%, which falls short of that national performance, which is 37%. So we're just not meeting that national performance. Court hearings are really, they're used to review the status and determine placement and permanency goals. So in those hearings, they hear quite a bit of information. That's the purpose on the court holding that type of activity. A little bit of federal background on this. The source for the 12 months, why do states and we have the 12 months? The Adoption and Safe Families Act is the federal guidance history with the 12 months. So there's federal law that requires that first permanency hearing to happen at least within that 12 months and then subsequent 12. So that's where Kansas law gets that 12 is from federal guidance. Within that, though, states do have some discretion. And so on the implementation of that, since it was enacted in the Adoption and Safe Families Act, some states have chosen to have those permanency hearings earlier. For example, some of those states with a shorter time frame for that first permanency hearing dates, and these are examples that we were able to get from Administration of Children and Families data. New York, Oklahoma, and Texas, they have that first permanency hearing within 6 months. Connecticut is 9 months. Virginia is 10 months. Then there's sort of this collection of states that has their first permanency hearing at a different time, and it's tied to the age of the child. So for example, in Arizona, if the child is age 3 years or younger, they have that first permanency hearing within 6 months. California, if they're age 3 or younger, it's within 120 days, which is about 4 months. More examples, Colorado, just next to us, is within 3 months in counties that have special programs for expedited permanency planning. So they have some jurisdictions within Colorado that have that ability to hear it. Georgia, if the child is under age 7, it's 9 months. And Vermont, children under the age of 3, within 3 months. Children ages 3 to 6, it's within 6 months. So there are states out there that have used discretion that's less than 12 months. With regard to that ongoing permanency hearing that needs to be held, that we want to change to be 9 months of that first permanency hearing, Georgia has their subsequent, or would have a subsequent permanency plan hearing held no less than 6 months after that. So they're also less than 12 months on their subsequent hearings, as is Oklahoma. Those are a couple of states' examples. Regarding fiscal impact, this would not increase expenditures. Department for Children and Families in our budget used an assumption that if this bill would pass and change the permanency hearings to 9 months, perhaps 50% of children who are in care might experience 2 fewer months in care. on the state general funds, that could have an impact of $4.8 million that would not be expended on foster care. All funds estimated at $7 million. And I have, in my testimony, I have some historical data with regard to the federal performance across years, and we would ask that the committee pass out this bill favorably. I'm more than happy to answer any questions.
Okay, committee, are there questions right now? Representative Page?
Okay. Thank you, Madam Chair. Do you think the courts are going to be able to keep up with you, in your opinion? You were shortening it from 12 to 9. Would the court system be able to keep up with what you're trying to do?
Thank you, Chair, and thank you, Representative, for the question. I can't answer for Office of Judicial Administration or each judicial district. Some conversations about the pace at which to hold permanency hearings has been occurring locally as a result of the Child Welfare Summit that occurred in April of last year, 2024. Some jurisdictions are developing, I'll call them like more local action plans. So some of this has come up. Our agency has had conversations with the Supreme Court Task Force on Permanency Planning, which is made up of judges and others who hear these types of things. It's our understanding, we have someone who participates in that, our attorney, Vivian Olson does, that they've discussed it and have been having conversations about it. I can't speak to the impact on each judicial district, but yes, it would mean that for their dockets or how they organize, there might need to be some adjustment period. Certainly Office of Judicial Administration, or perhaps, I don't know all the testimony today, perhaps they have testimony regarding the impact to how court operations could accommodate this.
Thank you, ma'am.
Committee, other questions? Representative Owsley.
Thank you, Madam Chair. And correct me if my memory is wrong. This came out of discussions we had in the Oversight Committee. And do we know current court practices? Are they currently keeping up with the 12 months? Or are we behind upon even the 12 months?
Thank you, Chair and Representative, for the question. We did ask Office of Judicial Administration, we've been in conversation with them and asked for them to be able to provide data on this. They haven't been able to produce a data file that they feel like is reliable to speak to the time in between, or the time to a first permanency hearing and between. So I don't have data to support that. Certainly I know OJA has communicated to us that they continue to work on that. I'm not aware of concerns that they're not happening timely. For example, in our Child and Family Service Review that occurred, it was not brought to the state's attention that was something that was a worry of case readers. However, Office of Judicial Administration may be able to answer that better.
Thank you for that response and information. Thank you, Madam Chair.
Any other questions, committee? I have a few, but I'm going to hold them and see if they get answered in another testimony. We do not have testimony from the courts, just FYI. I did not see any, so I don't know that they oppose it or they have an opinion. So thank you very much. Okay, next we will have our child advocate, Carrie Larnard. Is it Leonard or Larnard? You'll have to correct me. I want to get this right.
It's Larnard.
Larnard.
Larnard, yeah.
Okay, I'll have to practice.
My husband will tell people that it's lawn and nerd.
Lawn nerd.
Yeah.
Okay, thank you very much. Welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Carrie Larnard, and I am the child advocate with the Office of the Child Advocate, and I appreciate the opportunity to speak today on House Bill 2075 and in support of its passage. Just to highlight a couple things from my written testimony, the first thing I want to note is that in the Office of Child Advocate 2024 annual report, unreasonable delay in achieving permanency was one of our top concerns that we received in 2024. So when we're thinking about permanency, we know that that's an expressed concern that our office is receiving. And so in looking at solutions, Office of the Child Advocate does believe that House Bill 2075 is at least one piece of the puzzle to hopefully improving permanency for children here in Kansas. The Department for Children and Families, I think, provided probably way more extensive information in regards to data around the numbers here in Kansas, as well as the approaches of other states across the board. What I think I'll just take a few minutes this afternoon is maybe to speak to a couple of the questions that the committee just had for Deputy Secretary. So if I may, what I will tell you is that in my role prior to the child advocate role, I was a practicing attorney, represented parents, was a guardian ad litem. So in that role, more frequent, like when we appeared in court, it was everyone's focused. They're focused on that child. They're focused on that family. We're looking at how court orders are, the progress towards court orders. We're looking at the progress towards case plans. Work is happening all along the way. But when you have a hearing on the calendar and you know that you're going to be presenting information and evidence to the court, you're going to be advocating, we know that that means that there's an intentional focus on what needs to happen, where things are at and where we need to go. So improving that timeline, ensuring that you're in front of the court more frequently, it means that we're having a much more intentional look at that family to make sure that services are in place and that we're making progress towards permanency. I think the other, Representative Page, I know you had a question around just the impact. I obviously can't speak for the courts, but really just anecdotally from my experience as an attorney in this area is that courts, for the most part, the general practice, I would say, is when you have your initial hearing, you're setting your permanency hearing, that date is set out. So, if I'm at the temporary custody hearing, normally your judge is looking at the calendar and saying, okay, we're looking at the calendar 12 months from today, and we're going to make sure that this gets on the calendar. So I think for the most part, there's an intention to ensure that we're meeting that 12-month timeline. And really all that this bill then is doing is just moving that 3 months earlier. The impact for attorneys and the courts, it means that they're having court more often as far as the timeline, but it also means, hopefully, that we're achieving permanency more timely and more quickly, which means we're reducing probably the number of overall hearings, the number of children that are remaining in care for long periods of time. And I would be more than happy to stand for questions. Thank you.
Thank you. Are there questions, committee? It's after lunch, everybody's sleepy. No. Okay, so I have a question, and so my concern is moving too quickly to termination of rights. Do you think this would affect that at all?
Madam Chair, thank you for the question. I do not. At the permanency hearing, there are specific notice requirements, and there are specific findings that the court has to make. And so we're really just bringing it in front of the court to say, if our case plan goal is reunification, here is our case plan tasks, here are the goals, here's the things, and here's the progress that's being made. As long as progress is being made, I don't anticipate there being untimely or too early requests for termination of parental rights. I also think it would, as a parent's attorney at one point, I also think it's an important opportunity for then as parents to be in front of the court to say, here's the progress that I'm making, here's the things that I'm struggling with or the barriers that I'm facing. And it really gives then an opportunity to hopefully have some more intentional efforts then to address those challenges and those barriers.
Okay, great. And then I was intrigued by what Deputy Secretary Keys brought out about the different timelines for the different ages. Do you have any thoughts on that, since we're looking at this?
Thank you, Madam Chair. You know, I thought about that, and I didn't propose a change or an amendment to the bill itself, but there is, you know, a lot of states that have reduced it even more so, particularly around age, and I do think that this does give us an opportunity to think about child's time, and, you know, child's time for, you know, children that are, you know, 5 and under or 3 and under is very different than our 15, 16, 17-year-olds. And so, you know, there are models out there. We have the 0 to 3, or they call them, you know, baby courts. Sometimes you'll hear those references that do really have shorter timelines and more frequent hearings. And those outcomes are fairly good in those states that have implemented those programs or those types of courts.
Thank you. Natalie, is that something research could look at and get back what other states, maybe results? Or if you have any, Carrie?
Thank you, Madam Chair. We do have some information. I'm more than happy to pull some stuff together, but also, you know, I know that, you know, research.
If you have it and can pull it together, that would be amazing. I'm sure she is bombarded right now, so.
More than happy to do that, Chair.
Okay, great, thank you. And if you'll email it to Judy, then we can get it out to the committee. Are there any other questions? Representative Bergkamp and then Representative Carr.
Thank you, Madam Chair. I don't have much background with this, so bear with me. Sure. So when a child enters DCF, I guess at a minimum right now it'd be 12 months when they'd have to have a placement hearing. Is that correct?
Madam Chair, Representative Bergkamp, under the statute right now, once there's orders made as far as temporary custody, then a permanency hearing, as the Deputy Secretary has set out, there's federal guidelines that require that a permanency hearing be held every 12 months. And so that's essentially the required hearings. Now, some courts will have hearings more often. So you'll hear that oftentimes that they'll set a review hearing, and some courts will do that 3 months, some courts will do that 6 months, some courts will only hold those based on a request by one of the parties. But that 12-month hearing is when they're really looking at what the case plan is our goal going to remain reunification, or are we going to look at other permanency options? We're also then looking at services that are being provided based on the needs of the child and family, as well as placement issues.
So could, I guess, the former guardian request a hearing sooner than the 12 months? Like, is that part of the process, I assume?
Yes, Representative. So the guardian ad litem, even a parent's attorney, I mean, any, you know, sometimes our county or district attorney or prosecutor, they may file a motion or make a request of the court to set a hearing, a review hearing, or even a permanency hearing at an earlier date. But usually it takes those additional steps.
Okay, and then one more. So I guess if we moved up to 9 months, would the expectation be that we'd fall into like the national average for placement? Would that be kind of like the outcome goal?
Thank you, Representative, for the question. I think there's always the hope that these types of things would improve those outcomes. And I think, and I don't know if Appleseed is here present to provide testimony this afternoon, but they did provide some really good, I think, data and information in their written testimony in regards to the anticipated outcome on placement.
Thank you.
Representative Carr.
Thank you, Madam Chair, and thank you so much for the presentation. Curious question. What percentage would you say, even if it's just an educated guess, of these permanency hearings take place without the input or the presence of the biological parent?
Madam Chair, Representative Carr, thank you for the question. You know, that I don't know how to answer as far as percentage. What I can tell you is that there are notice requirements within our statute around permanency hearings, and parents are included as required to be provided notice. Now, whether or not we have the correct address, or if they've moved, or have they been in communication with their attorney, I think there's a lot of different factors that may impact that communication, whether they're able to appear, and whether then, if they're not able to appear, have they communicated with their attorney to request a continuance? Is the court willing to grant that continuance depending on the circumstances. So I think there's a lot of factors that may play into that. And I don't know how to predict a percentage, but it does happen.
So a follow-up, if I may. You mentioned that if they're unable to make it, that they would have the possibility then of contacting their attorney and have their attorney, are they provided an attorney? Or is that something that they have to go out and, during this process, do they automatically have legal representation on their behalf or otherwise?
Madam Chair, Representative, under our statute, parents are granted counsel, appointed counsel. They do have to qualify based on their income. So, and different jurisdictions approach that differently. So, some will require that the affidavit be completed prior to even the temporary custody hearing and appearance. Other jurisdictions will automatically appoint someone, and then depending on what their income is, then they may be requested to pay a particular percentage of that attorney's fees. But our statute does appoint and give them counsel in the cases. There are circumstances where a parent may determine that they want to proceed pro se, or they may request that or determine that they want to hire private counsel outside of the appointed counsel that was provided to them, but they are afforded an attorney.
Thank you, and thank you, Madam Chair.
Further questions, committee? Okay, I have one thought, and this will probably be the last one, and then I'm going to ask Secretary Keys if she wants to weigh in on this before our next testimony. So the bill says a permanency hearing shall be held within 9 months of the date the court authorized the child's removal from the home and not less frequently than every 9 months after. Is that just because federal law said 12 and 12, or what is the benefit with the follow-up 9 months? Is what I'm trying to understand. So we get the 9 months, and then we have the additional, right? Can you explain that to me, how that works?
Thank you, Madam Chair, for the question. And I have no doubt that Secretary may also have some input, or Deputy Secretary may have input as far as the thought behind that. The 9 months, I think what I believe the intention was probably just to substitute where we're requiring the federal guide requirements is every 12 months, and we're essentially substituting whenever there's a 12-month requirement with 9. So as you heard from the Deputy Secretary's testimony, some states have approached it differently. So they may say 9 and it could go back to 12, or they may say 6 for that initial one and go to 9 or go to 12, but it can't be, must be as frequently as 12 or less, if that makes sense.
So in my mind, if you get the ball rolling, like the court is we're in action, we get to 9 months, follow-up after that should be more quickly, because technically everything is in place. People know what they need to be doing. They're working the case. They're working hard. Am I way off of left field with that thought?
Madam Chair, I want to make sure I understand your thought process. So are you thinking that if we get to the 9 months and there's a permanency hearing, yes, are you asking whether you think it should be even more frequent than another 9 months out?
Yes. So like the next one should be within 6 months or 60 days, or I'm just asking for your being on both sides of it, right? Being the attorney and understanding those workings. I'd like your expert opinion on that.
Sure. Madam Chair, gosh, I think there's a difference between the permanency hearings and other review hearings that can happen in the interim. So I think the real issue is that permanency hearings require those specific notice requirements to all parties, and there's very specific findings that the court has to make and consider. I don't know that I want to land and say absolutely it should be sooner than 9 months after that initial permanency hearing. I do believe that more frequent hearings is beneficial and has impact. And so in those courts that do exercise and have the ability to have those more frequent review hearings in between permanency hearings, I think that that makes a significant difference as far as the progress in a case.
Jesse, do you have any thoughts on that? Am I understanding that correctly with the wording? Okay, thank you. Okay, any other questions for, oh wait, one more, Representative Barth.
Thank you, Madam Chairwoman. I actually, when you asked that question, I forgot I had that question initially too, because I'm not sure I fully understand then, like that the comment, it's page 3, line 9, where it talks about you have the not less frequently than every 9 months thereafter. So like they're having the hearing, the permanency hearing, and then why would they have the thereafter? Is there always a hearing thereafter that says, yes, that was the right choice? And so we're just saying 9 months and then another 9 months, not less than that, or not?
Madam Chair, Representative Barth, and obviously I'll let Jesse jump in too with that, but the federal requirements require that a permanency be hearing if a child is in out-of-home placement be held every 12 months. So if we have a hearing at 9 months or 12, and then another year passes, there has to be another permanency hearing. So I think that that's what that language is referencing.
Okay, when does it end? Is there an end date? Like, will this kid, what constitutes someone not actually having to have a permanency hearing in their life again?
Madam Chair, Representative, when the child achieves permanency, and so permanency can be reunified with a parent. Permanency can be permanent custodianship or adoption. Permanency can be our sole family, or it may be another planned living, essentially like independent living.
And that is confusing because I had to learn that, and it's still kind of confusing in my mind. Permanency is not just not moving in placement. Sometimes we think like, okay, they're in a stable placement, but that's not permanency. Permanency is out of the system, which is, yeah. Okay. Okay. Jesse, did you have anything to add? Okay.
Well, the very last option to your question is if permanency is never achieved and the child turns 18, then the child is no longer in custody of the secretary. So that obviously is a last resort, hopeful last resort. But then after age 18, they also have ability for independent living services through the department, but no permanency hearing.
Representative Esau.
Thank you, Madam Chair. And my question, I don't know if we know the answer to this or if the advisor probably knows the answer. There's no mandate on the court that at some point, this is our deadline. We've done a permanency hearing now 5 times. We're not going to ever do it again. Or we don't have anything concrete in statute that says at this point, we must have a permanent solution versus keep trying to do reunification, because we can see we're not making any progress. We can continue it on and on and on at the discretion of the court if they believe that the parents are making an attempt and it's in the best interest of the child to stay in foster care versus a permanent solution. Am I kind of assuming that correctly, that the court has that authority to just decide?
Representative, actually on page 3, if you look at subsection I, so when the court has made the determination that the child, it's being reintegrated with the family is not an option, then it gives them next steps in regards to how to address the future permanency hearings.
But other than that, there's no deadline on the court to make a decision. It's up to the court. Okay.
And it's up to the case plan, right? Just because every individual case it'd just be based on the participation and progress that's being made. Am I thinking about that correctly? Carrie?
That's correct, Madam Chair. So at the permanency hearing, I mean, what those factors that they're going to be considering is whether or not the goal, so if it's reunification, is reunification continue to be a viable option? And that's going to be based on the evidence that's presented, what kind of progress is being made on those case plans.
Okay, Representative Humphries.
But there are federal statutes that put a limit on it, that say we have to achieve permanency by a certain time. Do you agree with that?
Madam Chair, Representative, guidelines. There's expectations. It's attached to federal, federal dollars.
Right.
So yes, there's certain expectations, which is, when we're receiving those reviews, that's where a lot of those percentages come from, is that we're not achieving.
So have we ever had those funds withheld because we're not reaching the guidelines?
Madam Chair, Representative, that's a question maybe for the Deputy Secretary.
Thank you.
She's coming up next, so.
Okay. Yeah, thank you. I think they're mostly ignored in most states, but we'll see. I'd be interested to know more about that. Thank you.
Okay. Representative Page?
Thank you, Madam Chair. I taught school for 30 years, and I've seen how we've evolved with I don't know if I'm using the right term for it, but corrective justice, where we're trying to work with the kids. You don't want to rush, but you really want to help. And sometimes it takes time. And to put a time limit on it, because you may not have the right person working with them, or you keep trying to figure out what's going on and how can we do it. So to me, it takes time. And I know time is money and money is time. So you may not always be able to get it like that, but you want to help the kid and make sure that they're successful. So I get want to make sure we get our bang for our buck, but we're supposed to be helping. So I just wanted to say that I understand what you're saying. Thank you.
Okay, thank you. Any further questions? Okay, thank you so much. Deputy Secretary, do you want to come back for just a few minutes? Then we'll move on with testimony. If you want to just address the questions as you remember them, and then we'll ask your questions. Does that help? Yeah.
There's a requirement around, if a child has been in foster care 15 of the past 22 months, that's a time to consider more formally whether or not their current goal is appropriate. That's what we have for federal guidance. It's the only piece I might add, but I don't disagree that there's not a maximum number of months in federal guidance that a child would be in care.
And then just with my question on the 9 months, and then considering like what you presented with other states having different timelines for different ages, did DCF consider that when they were bringing the bill, or what was the thought process behind that?
Yeah, thank you, Madam Chair. Well, we did consider that, and we're open to that and would support that, and we're aware of other states who have those models. As I existed, I think, in our initial attempt with this and conversations that we were aware of, that a first good step, changing 12 to 9, might help us learn and also learn from families and courts and others that we are reducing the time that children are separated from family. But certainly we'd be open to other timeframes based on age that's been illustrated in other states.
And is there any thought for the second 9 months that we talked about? What are your thoughts with that?
I don't know that I have anything to add. I do think part of it was for consistency or continuity, changing both the 12s to 9. And that, again, because the permanency hearing is so specific with its purpose and additional pieces to it, and that coupled with then more the pace of review hearings or other types of hearings in between would be a good combination. Certainly, if more information is needed from on the other states who have the subsequent hearings shorter, we'd be open to that and happy to provide information that we know about. But the initial was simply to have it match, and changing the 12 to 9 and seeing that progress toward fewer months of separation of a child from their family while they're in foster care.
Yes, Representative Humphries.
So I just need to be reminded about this. So child's in care, and this is a little bit for, I feel like I should know this, but I'm confused at the moment. Child's in care, there's a permanency hearing within 9 months, but what I've seen in Sedgwick County in St. cases, maybe 60 months, or excuse me, 60 days or 90 days, the judge will have a hearing just to kind of see how things are going. And so, but it doesn't take a permanency hearing for the judge to make a ruling that, okay, the goal has been met. We're going to go ahead and reintegrate. You don't have to necessarily wait for that 9 months, or even you pass the first 9 months and the next permanency hearing is 9 more months. During that time, the goals can be met for reintegration at any point, and the judge could say it's, reintegration or adoption, whatever the goal is at that point. You can go ahead and do that, right? You don't have to wait for the permanency hearing per se.
Madam Chair and Representative, yes, thank you. Yes, that is also my understanding, that goals, specifically reunification, yes, could occur in between permanency hearings. The permanency hearings are a milestone to hear progress and make certain decisions, and has been said, provide certain notices, but there is case activity. There might be, a child may return home, or there may be, depending on the length of time in the care and the child's goal is adoption, there may be conversations occurring about that on a pathway toward legal permanency. This just speaks to when the hearings occur. There's other activity happening for the child and the family and their caregivers.
Okay, thank you.
Okay, so just to clarify that, when can a judge rule? Does it have to be a specific type of hearing, or can it be a review? When can a judge rule to dismiss the case, send the children home, put them with, terminate rights? When does it have to be a specific type?
Thank you for the question. I probably, since I don't work for the court and I'm not familiar with those sections of the Child Needed Care Code, I'll probably defer to others with expertise on the frequency and the purpose of the different hearings and notices required. For example, notice before a child is placed home and an ability for court to object. There's a number of different milestones or technical processes that occur that I'm not an expert.
Thank you. Jesse, do you have anything on that?
I believe that would be up to judicial discretion, just generally.
Okay. I'm looking at Carrie. Does she have anything different as an attorney? Thank you. Thank you, Deputy Secretary.
Carrie Leonard, Office of Child Advocate. Essentially, Jesse's right on as far as, judicial discretion. There are, and I don't have the code, I didn't bring the code with me. I should usually have it with me to reference directly. But there are specific findings and rulings that the court has to make, say, for example, at the permanency hearing. Let's for example, say we're at a review hearing. The court cannot change the permanency goal from reunification to, let's say, adoption. They would instead say at the review hearing, we're going to go ahead and set a permanency hearing to make that consideration and make that change. And then at the permanency hearing, if they're saying that reunification is no longer a viable option and we want to proceed to adoption, as our goal, then there may be the order that the prosecutor then file a motion to terminate rights within 30 days, and there's required service that has to occur. And so there are particular steps within each hearing, type of hearing, that would be required and expected.
That helps. Thank you. Thank you. Okay, any other questions so far? We have one last person that's going to testify, and that's Crystal Hedrick with Children's Alliance for Kansas. Welcome to committee.
Good afternoon, Madam Chair and members of the committee. My name is Crystal Hedrick, CEO with the Children's Alliance of Kansas. Thank you for the opportunity to testify in support of HB 2075. You've had a lot of good testimony around data and the technical approaches to this, so you can reference my written testimony, but I'll just talk a little bit today about some of the qualitative perspectives of this. But really prioritizing legal permanency and really creating a shared statewide sense of urgency for kids to reach timely permanency. So when we remove a child from their home, regardless of what that environment looks like, we're introducing a new kind of stress to a child's body and their brain. So these stress hormones have a direct link to adverse health outcomes, and we see that in our kids in care. And the longer they reside in care, even if they're in a stable placement, we see them struggle more and more. You see them being prescribed more medications to treat anxiety, depression, sleep problems, weight gain, inability to regulate their emotions, and some of those behavioral health issues. So while we may have removed them from a space where there was abuse and neglect present, it was a familiar space to them and a space where they did find comfort and knew what to expect from that environment. So it can take years for a child to recover from the uncertainty that comes from a family removal. So in Kansas, we usually reference family separation and foster care at the time in which a court makes the decision that it's not safe for a child to return to their home. A lot of other states across the country really walk that back and consider that initial family separation when the child's physically removed from the home or taken into physical custody as foster care. And that's really the moment when, despite our best intentions to create safety, we begin exposing them to new stressors and new trauma that they hadn't experienced before. The longer we expose them to that unknown, unfamiliar caregivers, schools, bedrooms, bathrooms, food, communities, the deeper that impact and the harder the recovery, and the more likely that they'll never be able to return to their family. So there are some areas in Kansas where kids and families only have one court hearing a year for that permanency hearing. And so 12 months for you and I and the other adults in this room is a whole lot different than 12 months for an infant or a 3-year-old or a 15-year-old or a 16-year-old who's missing an entire year of school and proms and friends and homecoming and sports and all of those things that are important to them. So we keep, as a state, continuing to prioritize legal permanency and felt safety through things like soul family. We can take it a step further now by prioritizing the length of time it takes to get to those permanency options. So we just ask that you support this bill, and I'm happy to stand for questions.
Representative Roser has a question online.
Hi, I'm sorry. I'm super sick, but I'm trying to follow. I just have a question. I don't know if it's necessarily for Children's Alliance, but um, we heard in our state of judiciary that there is a massive shortage of attorneys across the state. And so if we are shortening the time, I know that we discussed, if the courts themselves can handle it, but even having legal representation, but then also providing culturally competent services, which we're short on. And I don't know if we have this data, but if there are um, judges with specialized knowledge in child welfare across the state that have the ability to take this on. I'm just really concerned about that timeline and that access to resources.
Okay, I'm going to hold that question. We're going to come right back to it. Are there any questions for Crystal while she's up there? Representative Barth. Representative Barth, you go ahead, then we'll do Burkett.
All right, thanks, Madam Chair. I did want to ask, because it's current statute for 12 months time frame, and we heard the statistics and the percentage that Kansas is not even keeping up with the national average, trying to keep it as low as possible for permanency. Are you seeing a struggle to hit the 12 months? Do you think it'll be a challenge to hit 9 months? And if so, can you just, I'd like to talk afterwards as a second follow-up is, how are we going to improve that if it is an issue, if it's not great? Thank you.
Yeah, thank you for the question. I'm not sure that I can speak to the court's perspective on abilities to navigate some of that. I would say there are different practices in different court jurisdictions, and some of that might be based on the resources that they have available to them or not. But there are some counties that hold review hearings often and frequently based on a case-by-case basis. And I've worked in jurisdictions east of Wichita, so covering this half of the state. Yeah, so I think there's varying practices. Not sure how helpful that is, but.
Okay, Representative Burkamp. Sorry about that earlier. I wrote you down, and then I forgot.
That's all right. Thanks, Madam Chair. Hopefully you can help me with this. Do you know how many cases a typical caseworker has? And it might be for somebody else, but I'm just curious if you have any idea.
I think DCF has some reports on
Okay,
that they could speak to. Yeah.
Any other questions? Representative Bowsley?
Thank you, Madam Chair, and thank you, Crystal, for testimony. I think we all understand the importance of the expedient hearings, and I think from the questions in the committee posture that I'm receiving that this seems like a good idea and we should do it. But I also think that the child timeline and the younger youth to have that even quicker than the 9 months. You know, Deputy Secretary said they'd be open to it, but nobody's suggested a time frame for, you know, there were examples of time frames in DCF's testimony of what other states do, but I didn't know if anybody here had a Kansas example, and this question's for anybody. You're just at the podium and made a strong point. So I'd just be interested in any of the conferee's thoughts upon what a younger youth accelerated time frame might look like.
I'd have to research into what other states are doing and what's been effective in other areas, yeah.
Okay, any other questions? Okay, give me just a minute. Thank you for being here. Give me just 1 second. Okay, are there any other questions about this bill? Any discussion we want to have right now? Comments? Okay, so I'm going to close the hearing on this bill, but I'm going to put on the agenda for Monday to possibly reopen this hearing, and I'm going to try to get some court testimony to see if I can get them to weigh in on this and answer Representative Roser's question that she had, because I think that would probably be best coming from them. And then if Carrie would bring that information possibly on Monday, would that be too quick? Is that a yes? You can come up if you want. So I think that's important information. It seems to be interesting to the committee.
So Chair, I will make sure to get the committee the information that's been requested. Unfortunately, I can't be here. I have a funeral on Monday.
Not a problem. Thank you. Sorry for your loss. Okay, so that's what we'll do. We'll close the committee today, and then we'll revise the agenda to say we will possibly reopen it on Monday. Okay, is there anything else for the committee? We are meeting, the agenda's coming out today. We are going to meet Monday, Wednesday, and Friday next week. So same time, same place, but Monday, Wednesday, and Friday. And then we need to do the approval of minutes real quick. Does anybody want to make a motion? Representative Neighbor.
Thank you, Madam Chair. I would move that we accept the minutes of 116 and 122 as written.
Okay. Is there a second? Thank you, Representative Carr, seconds. All in favor? Okay, minutes are approved. Anything else for the good of the committee? Okay, thank you.